Well, that picture that was taken of me, I have a little smile there. That wasn't after I heard about AB 1482, I can tell you that. You know, I won't get political. You know, we can do that another day. But, you know, the reality is it's a boring, dry, horrible law. I'll try to make it as interesting as I can. But I have to tell you, it's only one step up from teaching a RESPA class. It's just not that interesting. The impact is more direct and more immediate to each of you, though. And before I get into that, I do just want to reiterate one of the points that Carla had shared, which is your membership and your contributions to SDAR are critical. You know, we all donate our time, we all do what we can to assist the association, but in the end, it is that Army, and you fund that Army. You make this happen. So it's your contributions that allow the voice to be heard so that we can control what's happening out there, because there is, in my opinion, a very, very strong movement toward attacking, I think, you know, I don't want to be an extremist, but it's attacking our community, basically what we do. You know, whether it's you're going to be an independent contractor, whether we're dealing with sea change, elevation issues and what's happening there, all of this stuff impacts what we do. And it's more than I've ever seen in all of the time that I've done this. While I'm not a realtor, I actually did take some classes a long time ago, and then for whatever reason, I must have gotten hit in the head because I became a general contractor instead. Anyway, I've worked with developers, I've worked with realtors the whole time. The truth of it is, everything that I've accomplished in my life came from the first piece of property that I bought. From that piece of property, I was able to take some equity out, buy another property. I was one of those early flippers. When I learned I could do a double escrow, I quit my retail job and basically started doing that, and then started developing, and then bought and sold some land, and that was enough to pay for my law school. So I'm a big believer in what you do. What you do is everything that I've accomplished, essentially. It gave me the foundation for it. And because of that, I've had a very, very strong allegiance and tie to the realtor community. I was fortunate enough early in my career, really my first big case, where I was defending a listing agent that was being shaken down in a lawsuit. And I said, wow, this is a lot more interesting than contractors. And from really that first case on, I said, that's it, I'm working with realtors for the rest of my career. And that's what I've done for 23 or so years now. And I'm glad to talk about issues like this. My goal is, while I appreciate everybody in this room, I would rather spend the time up front today speaking with you than defending you in 6 months. That's the truth of it. While I recognize a few of you in the room, I won't mention any names. That's okay. Maybe one of you even sued one of my clients. That's okay. You know, I respect you too. It's fine. But in the end, I think education's the key. You know, we want to basically keep ourselves out of trouble. So you've got a little bit of an outline there. You can jot some notes down. The truth of it is, you're gonna leave here today. Your head's gonna spin a little bit. You're gonna be a little frustrated still, but you'll have a better understanding. You may not get every last point, but we'll follow up from SDAR. You know, we'll be issuing articles out, and we'll be getting you what you need, so you've got more of the detail. I do have certain portions of the code quoted because those are things that you will need. Carr's going to be working on a form for this as well, but the truth of it is you don't have it today when you go home, so you're going to be a little anxious about it. So our commitment is we'll get that to you. That's basically, we start with this because that was the quickest thing we could do for you. So I think with that in mind, we have to consider, yes? Yeah, basically we had a request to turn the lights on so they can take notes, because you're like me, you've got to see what you're writing or we're in trouble. I know I've got horrible handwriting, but if I can see it, it helps. So, okay. What precipitated this, as we know, is we've got a housing crisis. And so basically they said, what are we going to do? Well, let's figure out, let's legislate our way into it, and we'll tell people what they need to do. So let's have rent control. And that was the idea. It was basically modeled on a UC Berkeley Center for Housing Innovation group that said, hey, you know, I think if we can limit it to 5% plus inflation, that would be reasonable. And it very closely tracked that. And of course, the primary author of the bill was from the Bay Area and said this is what they want to do. So lo and behold, as Brian had told you, Shazam, even though we had all spoken at the polls, they quickly said, let's ram this law through and get it done as quickly as we can. And that's exactly what happened. They say essentially that the law is going to affect 2.4 million units is the idea. That's big, okay. And the effective dates basically are January 2020, and it ends in 2030, or I'd like to say sooner, if somebody wants to do something about it. So that's the question of how can we weigh in? What can we do? I think the people need to speak again. I think we need to be loud and we need to be heard, because I don't want to see this law around till 2030, and I think that the legislature didn't consider what I always refer to as the law of unintended consequences. I don't think that all legislatures are bad, even the legislatures that I don't agree with. I don't think they go home at night and say, how can we screw the people? I think a lot of the times they believe what they're doing. They're just misguided sometimes. We all make mistakes. But I think ultimately they need to understand that, just because you're going to legislate doesn't mean it's going to happen properly. You get these consequences or the fallout. I mean, we talk about the rent increase, the caps. Well, what am I going to do if I'm a landlord? I tell you exactly what I'm going to do. I'm going to increase it the maximum amount every year to make sure that I'm getting screwed as little as possible. So what are you really doing? You're legislating, if people are paying attention to the law, and a lot of people don't, but if they're paying attention, you're guaranteeing 5% plus inflation every year to these people who already are barely able to afford what they're renting. I don't think that's the answer. I just don't. I mean, I'm going to get a little passionate about it because it bugs me, I just don't think it's the way to go. So that's one consequence. Another consequence is, I think, if I'm a landlord and I can get rid of somebody, you see, now my relationship with my tenant's a lot different than it used to be. I used to like a good tenant. I've been a landlord. I had properties in 2008 and I didn't want to short sell them, so I was an involuntary landlord for a while, where I held those properties and then eventually sold them. The important tenant to me was the tenant that didn't create problems. It was the tenant that paid the rent regularly, that would be long-term, that I wouldn't have a vacancy, because I knew that if they left, those 2 months that it was vacant, I wasn't getting any money in. So was I willing to take a little less rent from a good tenant? Absolutely. That's the tenant I want. But now my relationship with them is far more adversarial. I almost don't want my tenant because I want them out, because I want vacancy decontrol. Basically, when it becomes vacant, now I just get to raise it to whatever I want. And the market will tell me whether they want to pay it or not. If I'm crazy, well, the market will tell me and they'll pay it or they won't pay it. So I've got a very different relationship with my tenant than I had before. I don't think that's how you solve a housing crisis. I mean, I know I'm on my soapbox and all that, but it's true. I don't think that's the solution. There's never one easy solution. It's usually a combination of things. I'm a big believer in, and I always say that, I know this from defending people, adults are really just big kids with bigger clothes, but they're still kids, okay? They have a driver's license and now they can vote, so it's a little more dangerous. But in the end, I realized I could have a lot of rules for my kids, and when they're really young, they'll kind of listen to you. But when they get older and they're a little more free-spirited, telling people what to do and forcing them to do it isn't always the answer. I learned a long time ago, you should have people, you should motivate them to take the action that you want. Well, that's not telling them they have to do something, it's making them want to do it, showing them that there's a reason to do it. So I'm more into incentives as opposed to rules that say no, no, no. It's more how can we promote the housing. So that's a whole other discussion for another day. I'll move on or we'll never get through this. But in any event, that's my little rant. Okay, so now let's talk about the application. What does this law apply to? Let's start there so you know whether it even matters for you or not. Okay, and it applies to properties that are not already subject to more restrictive rent control laws. So if you're in the People's Socialist Republic of Santa Monica, don't worry, you're still protected, I guess. You've got what you've got there. In any of these other jurisdictions, if they've already got their law, it doesn't necessarily undo it, but it's everywhere else. Well, that's us. That's all of you in this room, right? So that's going to impact you. It deals with units that are over 15 years of age. Okay, so that's a rolling issue, right? So you go 15 years back from January 1, 2020, and then, in 2021, you go 15 years back. It's always going to be, it's going to continue to move on. So it's always, for example, the example is, it means units built in 2006 will be covered in 2021, units built in 2007 will be in 2022. The idea is, it's older units. Maybe the thought was, well, we want to stimulate construction of new units that these people are going to put into the marketplace to rent. But that's not the way that I look at it when I build a property. I look at it, I want to milk that property for everything for as long as I can, and I don't just want to get it out in 15 years. Irrespective of how I treat it and depreciate it, I still want to be able to make as much as I can for as long as I have it. And even if I'm not going to have it, I have to sell it in a secondary market. And we all know, what's something worth? Well, if it's an income property, it's worth based on what you can get for it. And if we've artificially depressed that, how's that going to resolve the problem? That's just going to be a bigger problem. But anyway, it's the 15-year mark, so you need to know that for starters. For commercial properties, we'll get into more exemptions, so don't worry. Another thing is, we've got a lot of ground to cover, so I'm probably not going to be able to take questions as I'm moving along, but in the end, I'll take some questions from you, and then ultimately, they're going to kick us out of here at some point. I'm the smallest in a big family, so I have to talk a lot and talk loud. I'll do that outside if they kick me out. So if you have questions, I'll stick around for you, okay? Anyway, and it's basically 2+ units, right? So, and even then, there are exceptions. We'll get to it. What are the exempt units? The exempt units are single-family homes, townhouses, condos, unless owned by a corporation or a real estate investment trust. So here's the challenge that I have with that. Let's say I have a client that says, you know, Rob, I'm trying to protect myself. I'm actually going to come to you before I get sued, not after. It's usually a good way to do it. It's the type of relationship you want to have with an attorney, ideally. I say we're like arsenic. A little bit's good. We put it in the water supply. We can drink the water. Too much arsenic, we die. Attorneys are the same way. A little bit of an attorney, very good thing. Too much of an attorney, if you're not dead, you wish you were. So we try to avoid the attorneys. So the client comes to me and they say, I want to protect myself. So they put their property into an entity. They put it into a corporation. Well, guess what? The thanks they get now is, even though it's a single family home, oh no, you're one of those capitalists. You're commercial. We got a problem with you, so your exemption's gone. You don't have an exemption. So you need to be careful with that. A big takeaway for the property managers in the room that say, what do I do? And my landlord wants to raise the rent and they want to know about, they've got a corporation and they want to know all this stuff. While it's very important for you to know as much of the law as you can, and I'm not saying send them to me, this isn't a self-employment act for me, but I think your position is you tell them, I spot issues, I'm a realtor, I see red flags. And then when I know it's a legal issue, I tell you, you should really talk to an attorney about that. That's beyond what I did. Now, a lot of times your client's going to turn to you and say, what good are you? What am I paying you for? They all do that because we know clients will have you do everything. I mean, if you're not careful, you'll be taking the kids to school and picking up the dry cleaning. They'll have you do everything you're willing to do. That's the way people are. It's their nature, okay? So I think we've got to be careful with it. And I think what you have to tell the client then is, that's a legal issue. This is really something that you need to go talk to a lawyer about. Dump it on the lawyer. Now, the client's going to get a little frustrated and say, what do I pay you for? We all know we get that pushback, and that's when you tell them, well, look, my job is to tell you what I know, but also to tell you what I don't know or what I shouldn't know. You're far better off to hear that from me today than 9 months down the road saying, why didn't you tell me you didn't know? That's not really what I want to know. I need to know today. Sometimes I have to tell people things they don't want to hear. However, we're all effective salespeople. We can sell that if we need to. But if they're still pushing back, then I give them the example. I say, look, if you have a tax issue, I've got a TurboTax disc in my trunk of my car. But this doesn't mean I'm going to do your taxes for you just because I've got the disc. That would be foolish. I'm a realtor. I'm not a tax person. You got to go to a CPA or you get the disc and have fun with it. But I'm not doing that. They start to appreciate it, and then ultimately you tell them, I'm not going to give you legal advice any more than I'm going to give you medical advice. Now, the truth be told, I could go to WebMD. I could look it up. I could spend some time there and give you a qualified or unqualified opinion. But the truth of it is, I know that if I go to WebMD, after about 15 minutes, I'm either dying of cancer or I just need to get more sleep. I don't really know what the hell's wrong with me. I've got all kind of, I'm bipolar, I'm ADD, I'm everything. All I know is there's a commercial on TV trying to sell me a drug for it. That's all I know. So and once you explain it to them that way, they get it. They go, okay, I appreciate it, thanks a lot. And you follow that up with a little email and you save that so they can't later on come back and invite you to the party and say, hey, but you told me. Oh, no, but I didn't tell you. And that's why I always confirm things in email. Email's our friend. Emails, it was so nice to see you today. It was lovely, happy to hear about the kids. Oh, you know, as we discussed, blah, blah, blah. That's the CYA, that's the second part. That's why you're really writing it. You know, and then you end up with something flowery, you know, looking forward to whatever, blah, 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 and you move on with your life and you save that email in perpetuity. Okay, because when you have that email and they invite you to the party, I'll get you out. But when you don't have the email and you're the one that bore fiduciary duty to them, we're going to be spending some quality time together. And you don't want to do that. There's a better way to spend your vacation than with Rob. I'm just telling you. So you don't want to do that. All right. So duplexes. Okay. Now duplex can be exempt if one of the two is owner occupied. And then we'll get into some more exemptions, but you need to know that. Okay. So let's talk about the rent regulation. That's the first part. What does this really mean? And basically what they're saying is it's a cap. They don't like to say rent control because that's a bad name. Oh, it's rent control. Okay, call it what you want. There are a lot of different names you could come up, but we won't repeat those. 5% per annum plus inflation can never exceed 10%. So you say, okay, 5%, that part I understand. I can do that on my iPhone or whatever, or my Android. That part I get. But what's the inflation? How do I calculate the inflation? Well, you go to the Consumer Price Index and you look at it, and then you go, well, geez, I'm already scared because, you know, realtors starting to do math and going to alternate sources looking for things. You know, I wasn't good at math either. That's why I had to become a lawyer. So, I mean, it's an issue. So you go to the Consumer Price Index. You can go to the regional one for San Diego, and you say, okay, here it is. It's San Diego. But even that's an issue because it's supposed to be April to April. But the CPI, the regional CPI, is released on alternate months. It's released in basically January. It's odd months, January, March, May, blah, blah, blah. So you can say, well, I don't have it for April, so what do I do? Well, some people are going to try to get cute. They're going to practice what I call agent law. Agent law is just the law. They believe it and they say it. And as soon as somebody else repeats it back to them, that's like the Supreme Court. It's law now. So it must be true. And so that we don't want to practice agent law, okay? If all you have is March and that's the applicable one for your region, then that's what you have to use. And let's not get cute and try to get the last 1/10% because we didn't round it properly or whatever. Let's not be cute because if you violate it, you trust me, that's when it's going to be an issue, and we'll get into that as we go a little more deeply into it. But basically, what does that translate into in San Diego? For the last March to March, that's accessible. It was 2.2%, so it's a 7.2% increase. So I'm thinking, well, I know that's what I can count on. And, you know, in the future, I'm going to continue to look at it, and I'm going to probably, you know, the state tends to be a little higher as an average because we have to factor in the Bay Area where it's even more insane. You know, San Francisco and other areas, although they've got their own crazy rent control up there. But in any event, you go and you'll get your calculation, and basically it's for the 12-month period. We'll get into how many times you can increase it and all that stuff and how that all goes as well. The other thing is, and I know what a lot of you are thinking, you're thinking the first thing I thought. I don't like rules, I have a control issue, or I don't like authority, so that's why I had to become a lawyer probably. And so my first thought is, well, I know what I'm going to do. I'm going to raise my rent today. Let's just max that rent. Well, for you rent gougers out there, that's how they view you. You don't really get to do that because there's a reach back to last March 15th of 2019. That's going to be the operative rent. Okay? So, well, it sucks to be me. For a minute, I thought I had it right. Well, you don't, because you got to reach back to March 15th. They figured that part out. Even when you don't like what they do, they figure that stuff out. So they say, okay, now what happens if between March 15th and December 31st, I raise the rent more than 7.2%? Because that's who I am. That's what I wanted to do. That's what I could do with the same tenant in place. What if that would be in violation? You're okay for the interim period because the law takes effect on January 1st of 2020, but you can't do it going forward. I think I'm driving the camera guy nuts back there. I'm moving around too much. I'll just stay right here. So anyway, you basically, you don't have to refund it, but you still have to look at where am I on January 1st of 2020 and where was I on March 15th. Okay, and then you'll see whether you're in violation or not. And I know we're going to get a couple people that are going to come up with some crazy mathematical calculations here and ask me crazy questions. That'll be later, okay? So anyway, no last minute gouging, all right? Maximum adjustments to rent in a 12-month period, okay? Because the other thing is they're trying to protect people and they're saying, we don't want you raising the rent every month. You're going to be driving this poor person crazy. Plus, it's just a recipe for disaster anyway. And the answer is, for renters who've lived in the unit for more than 12 months, you may raise the rent up to 2 times within that period, but the total increases still can't exceed the cap. Okay, so you're going to have to, it's not like I can do it and somehow I can do it 4 times and I can get more than the cap. The cap's the cap no matter what. It's just how many times can I adjust it, okay? Because some people will want to do that along the way. Maybe they want to follow it. They want to get a little more income in there if they can, okay? A question is, do the landlords want to renew these tenants? Do they want to keep them in or do they want to get rid of them? What do they want to do? And that's where I wrestled with the law a little bit because it wasn't entirely clear until I read it 3 or 4 or 8 times and got a little more frustrated each time. But what happens if I'm at an end of a lease and I say, great, I'm at the end of the lease. It's time for me to dump this tenant. I love them, they're great, but they're a problem because they're an impediment between me and what I want to charge. So maybe I want to get rid of them. Well, just because the lease is over doesn't mean they might not have a right to want to renew that lease. And so the question is, well, am I stuck with them? And the answer is, you have to give them an option to renew. It has to be reasonable. It has to be reasonably similar to what the existing lease was, other than for the increases. Well, oh my gosh, that absolutely drives me crazy. Because my thought is, if I own a property and I want you out, while I know that I certainly can't discriminate based on certain things that we're not allowed to discriminate over, which are appropriately in place, there are reasons why I will discriminate against my tenant. What if I just don't like them because they're trouble? They're within the law, but they suck. I mean, they're just a horrible tenant. I get too many damn phone calls. I had one of those. I had the tenant that paid the rent on the first of the month, every month, without fail, but the owner downstairs kept complaining. Your tenant's making too much noise. And so I talked to my tenant. I'm like, look, they say you're making noise. I don't really know, what's really going on. And they're like, look, yeah, I make some noise at 2 o'clock in the morning. I'm in the kitchen, I'm doing things. And I'm like, well, it's 2 o'clock in the morning. I mean, really? Their bedroom's right there. I mean, how are we going to get along? If you want to make noise like that, get on the first floor, but you're walking on their head. They're going crazy. The baby's crying. I'm getting phone calls. And so they're like, I don't make any noise. So I told the tenant downstairs, the other one, not mine, I said, you know what, here's the deal. Here's my phone number. You call me in the next 2 weeks. Anytime, any night, any time of the night, you call me and I will come over within 15 minutes and I will sit in your unit and I will hear it. Because if I can hear it, then I can say something. Well, sure enough, I got the phone call at like 1 in the morning and I got in my car and I drove over there because I'm just trying to keep the peace, man. I don't want to have these problems. Sucks to be a landlord. I go over there and sure as hell, man, it's like they're having a polka fest up there. I mean, I'm like, you gotta be kidding me. So, I text my tenant. I'm like, hey, are you awake? Oh yeah, I'm like, I know you are. I'm downstairs, I'm hearing it. But I couldn't just get rid of them. It became a real issue. So there are tenants you just want to get rid of. And we won't necessarily be able to do it. So we'll get into the just cause and the reasons why you can get rid of tenants. But the truth of it is, in my opinion, it's already too hard to get rid of tenants sometimes. And now they're going to give you just more reasons to make it difficult, which means even more reasons to need an attorney, which is not the way we should be running our society, but it is the way that it is. So, okay, they're not going to want to renew some tenants. That's the way it is. Okay, so let's get into the just cause of evictions. They talk about just cause. You have to have reason for doing it. Now, we all know there are reasons why we can evict tenants. There are good reasons for wanting to evict them. Just cause obviously means you have a legitimate reason for doing it. And the law requires that you provide a reason for the eviction and the notice to quit. And you've got to you got to give them the reason. You can't just say, I'm not renewing your lease. I've elected to not renew your lease. You have to say, if there's a reason why you're not renewing their lease, like they're destroying the property, you got to say, because you're damaging the property, because the police have been out there, because you've been convicted of a felony for dealing drugs from the unit, whatever it is. I mean, you have to talk about that, which again, if you're property managers, you better talk to somebody to help you out with that. Don't just start thinking you're going to go on the internet. Google is not always your friend giving you the answer to how you need to fill these forms out. You need to talk to somebody about that, okay? So, as far as these just cause evictions apply, which renters do the eviction protections apply to? As of January 1st, 2020, it applies to renters who've resided in the unit for 12 months or more. So again, I'm thinking to myself, if I can get rid of a tenant in November or December, do I want to get rid of them because I get an extra 12 months to deal with? You know, how's that all working? I don't know. You got to ask yourself that if you're a landlord. The short term is, I don't know that people will think that much, but I would. If I had a unit that was coming vacant right now, I'd be inclined to want to get rid of somebody, although it's hard to place a replacement tenant sometimes over the holidays. You got to make that decision. That's your call. However, and this is where the law becomes, difficult, and they give you more layers. If an additional renter is added to the lease prior to the existing renter continuously residing in the unit for 24 months, then the just cause provisions do not apply until all renters have continuously resided in the units for 12 months or more. So you can't just add somebody. If they add somebody in, that might extend this time out a little bit. So that's an issue. And again, these are going to get into some of the details where you're just going to put a star next to it and say, okay, I got to follow up on that. That's where you'll read our article. We'll give you the information. Okay, now, just cause is divided into two categories. There's at fault and there's no fault. Okay, at fault is shame on you. You've done something you shouldn't do. I have a reason for getting you out of the property. So the at fault is the typical things. Failure to pay rent. Breach of a material lease term is defined by the law. Oh, that's great. So now I got to talk to a lawyer about that. Maintaining, committing, or permitting the maintenance or commission of a nuisance is defined by the law. Well, it's probably if you're having a rave at your property every night at like the Polka Fest. I don't know if it's loud enough. Maybe that gets into it as well. Committing waste is defined under law. You're basically dumping toxic waste at the property or somehow destroying the property. For a written lease that's terminated on or after January 2020, after a written request from the owner, the renter is refused to execute a written extension or renewal of the lease based on similar terms. So if you have somebody in there and you're saying, look, I'm willing to extend your lease, under similar terms, and they don't reply back to you, you don't have to wait for the rest of your life to say, well, you're in there forever. Now the question is, how many days is that exactly? Is that 10 days? Is that 3 minutes? Is that 2 weeks? They don't tell you exactly what it is. It's reasonable. Well, if reasonable, we could agree on that. The divorce rate wouldn't be more than 50%. So reasonable is a recipe for lawyers, unfortunately, so it's reasonable. I mean, obviously, if they're not getting back to you, for a long period of time, for a month, clearly that's unreasonable that they're not getting back to you. But even that's based on the facts and circumstances. If the person's in the military and they're deployed, I mean, maybe they can't communicate with you. So you're going to have to take it based on each set of facts and circumstances. Criminal activity by the renter on the property, including any common areas. Criminal activity or criminal threat on or off the property that is directed at any owner or agent of the owner. So, if the tenant's crazy and they threaten to kill you, that's probably a good reason for wanting to get rid of them. But again, you got to prove this stuff, right? So hopefully they're dumb enough to send it to you in a text message or an email or leave it on your voicemail. And criminals, that's my experience when I clerked for a judge. The common denominator frequently is they're not that smart sometimes. I remember when the 3 strikes law came out, and there was a guy in there for a second strike. And he's thinking, I'm just a cat's meow. This is just a second strike, so you're going to negotiate me down because you got to try all these 3 strikers. There's a backlog. But I noticed, the family gets to bring you a suit when you appear in front of a jury. They'll bring you something so you can look good. So they brought it. And in the morning, the shoulder pads were really big in the suit. And I was young and I just bought some suits and I was paying attention to this stuff because I spent my money on my suits. And I'm like, well, God, that's weird. And then the afternoon came down, the shoulder pads were really small. And I was like, I told the bailiff, I'm like, hey man, what gives with this guy's suit? Something's not right. Turns out he'd smuggled a bunch of drugs in. The family brought it in the shoulder pads and he got caught for his 3rd strike while he was waiting to be tried for a 2nd strike. Bad move. And it's aggravated because you're bringing drugs into a government facility and a jail and all that. So the guy went down. So sometimes they're not always that smart. You know, they think they're smarter than everybody, even at the highest levels. At the highest levels, a lot of times they're smart enough to get away with it until the people ask them questions afterwards, and then they get caught in the cover-up. That's why Martha Stewart went to jail. It wasn't what she did originally. She wasn't honest when they asked her the questions later on. So, you know, honesty can be a good policy. In any event, assigning or subletting the premises in violation of the lease. Refusing the owner access to the unit as authorized under the law. So you're giving your notice, you want to come in, you want to do your inspection, and they're not letting you in because they got a big grow house or, you know, whatever they're doing. Bottom line is that's not cool. They got to let you in. My little trick as a landlord is I say that I like to come in and I check the smoke detectors regularly. And that's my excuse to get into the unit. I give them notice. I tell them right up front in the lease early on because I need to get in there to make sure, because I've had too many cases where they turn it into a grow house and they destroy the place and you have no idea. And it happens here. It happens in I've had it happen in some really nice gated communities. It's like that show Weeds that used to be on Showtime. That stuff happens, man. I've been in those houses and they trash them. So that's my excuses. I get in, I check the smoke detectors, blah, blah, blah. Okay. Employee, agent, or licensee's failure to vacate after termination. So you have a resident manager, you know, and you've terminated them, and now they're not, you know, that was part of it, and it's time for them to go. Well, they don't leave. That could be a just cause as well. Another one is failure to deliver possession of the unit following written notice of the renter's intention to terminate. So there, you know, there's an agreement in place. They're going to terminate. Say they're going to be out on the 15th of the month, and, you know, the 16th, the 17th comes. Well, okay, guess what? You're in violation. So that may be a just cause. What about the no fault? That's really the one that more of you probably, you know, the other ones are typical. You're being a dirtbag tenant, you got to go, I get it, okay? But what about the ones where I've got, you know, I need to get rid of them and they're good tenants. They pay their rent. They're not having a polka fest. You know, I'm not getting complaints about them. Are there reasons why I can, you know, get rid of those folks perhaps? And that is basically where the action is based not on the actions of the renter, but it's based on something that deals with an owner's need that's excusable or a governmental regulation that requires it. So one cause can be owner occupancy. If you're going to move into the unit, I mean, they were talking about a housing crisis. Well, what if I want to move into the unit? Well, if you legitimately are the owner and you want to move into the unit, you could do that. However, you know, let's not get cute, folks. I mean, again, agent law, people start getting, I always say when realtors start getting creative, you know, we say in my office, oh, creative's on line 3. You know, creative is usually, if you get real creative, it ultimately, the spectrum of creative ends up at fraud. That's the ultimate creative. Okay, so I get a little nervous when I hear anybody say I have a creative concept on the phone. I'm like, ding, 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 3 kids in college. You know, but seriously, I don't know that you need to do that. So watch out about the creativity. Don't, you know, say I'm moving in for a week and, you know, then I moved back out, I changed my mind. That's going to be a sham. I mean, you got to pass the smell test, folks. You got to do it for real, okay? But that can be a reason, okay? However, understand this, for leases entered into after July 1st of 2020, they're kind of staggering some of these issues. The owner would only be permitted to occupy the unit if the renter agrees in writing to the lease termination, or the lease includes a provision providing for lease termination based on an owner or relative occupancy. So if you didn't have that, this is the gotcha. These are the little gotchas in the law. If you don't have that language in there saying that I reserve the right to occupy this, you know, the owner or the owner's immediate family, domestic partner, etc., if that's not in the lease, you don't get that protection. Now, you know, when CAR comes out with their document, I'm sure they're going to have that in there as a default that they maintain that option because CAR knows what they're doing. Kevin's shaking his head. He'll get to deal with the commas and all the semicolons and the crazy stuff.
We'll talk about it in new forms.
Exactly.
On the 4th of December.
Yeah, so there you go. They're working on it right away. They will put that in there, but the bottom line is that is a little gotcha. You need to make sure that you've protected yourself there. And,
say that again real slow?
yeah, so you have an excuse to get rid of somebody, and that is if I'm an owner and I want to occupy the unit myself, okay, I can terminate the lease. That is a no fault, but I'm allowed to do that. However, in my lease agreement with the tenant, I need to have language in there saying that I reserve the right to do that. So if I don't warn them up front that I may have the right to occupy this unit if I so desire, or my immediate family, etc., then you don't get to use that excuse to get them out. So you need to make sure that's in the lease. They need to know that going into the deal. It can't be a surprise, surprise. Yes?
What happens if you want to sell?
Selling a property doesn't get rid of the inalienable right of a tenant that's a protected class in California. So unfortunately, no. And that's one of the reasons why the Army of Realtors is probably going to be a little frustrated with this. Okay?
On the owner moving into the property.
Yes.
What's the significance of the July 2020? That's when the wording has to be in the lease?
Correct. That's the date that's got to be in there. Although, quite frankly, if I'm doing leases, I'm not one that says, let me wait to the day and do it. I do it now because it doesn't hurt me and I don't want to forget it. I want to do it while it's fresh on my mind, but that is the critical date for it. Another way, and I had a very interesting question from an individual today that said somebody donated a property to our nonprofit. It's a church. And they said, you know, we've got a tenant in there that was given a sweetheart deal, and they're paying what sounds to me like it's almost like the church is paying them to stay there. It's ridiculous how low the rent is. And they said, what can we do about this? I mean, you know, even if we increase it 7.2%, I mean, this is outrageous. And truth be told, we want to sell the property, but we know if we sell it with a tenant in there, you know, that's hard to market, and who wants to do that, and who wants to buy it with this tenant in there at this loser rate? It makes no sense. What can I do? It's an old property, you know, it's got asbestos, it's a disaster perhaps, and this is the first time I heard asbestos and my eyes lit up. And I thought, well, congratulations, this is the one time in your life you'll be glad you have asbestos in your unit. Can you believe it? Law of unintended consequences. This one comes back to you. If you're doing substantial remodeling that requires the tenant to vacate for their safety for a period or requires a permit, and it's of a substantial component, takes 30 days or longer, you could terminate the lease based on that provision. Great! I need to do asbestos abatement. So the legislature is going to clean up the asbestos in California with rentals, perhaps. They didn't realize it. Now, it can't be there's a little popcorn in one corner and I'm just going to have, you know, some guy from the corner at Home Depot scrape on that and say that I'm doing asbestos abatement. You better prove that you legitimately had a company come in there and give you the certification that it is asbestos free, that you did the work. It could be other substantial components. Replumbing, rewiring. But again, it can't be something that the tenant wouldn't need to leave for. Now, if there's going to be no plumbing in the unit for a significant period of time, that's not habitable. Can't flush the toilet, that's a good sign it's not habitable. Okay? You shouldn't be taking showers outside with a garden hose, that's not habitable. So there are, you know, if it's substantial, a total repipe, you know, total rewiring. But even that, remember, it's that 30-day, and you got to remember to get a permit. You just can't have your handyman doing this thing, signing a little napkin saying that he did the work. It's got to be legit. But that's a reason why you might be able to terminate. That could be a no fault. And I guess the legislature realized that people need to fix their properties up sometimes, and maybe that's a good thing for housing. So that was a carve-out. There are some of these carve-outs, and those were hard fought. Those were things that Brian was barking about when he was there, you know, working really hard, because I will tell you, the earlier revisions were insane. Yes?
Are we talking about 12-month lease, or are we talking about any lease, like month to month?
It doesn't matter if they've been there for more than 12 months.
Then-
Yeah.
then even if it's
But the truth of it is, you're not going to raise somebody month to month, and if they've been there for 12 months, it's probably, you know, you're not going to raise them every month anyway. But if you do, you can, you know, you've got a limit of twice in 12 months, right? And you've got the caps, so it really doesn't matter in the end. Yes. She knows my name. That could be a problem.
I wanted to go back to the sale of the unit.
Yeah.
So if an owner decides to sell the property,
Yeah.
if it was less than 12 months or more than 12 months, I'm a little confused as to you saying that that is not a reason to get the tenant to vacate. So if you have owners that are wanting to sell their property, 1031 exchange or whatever, get out of is that going to be a problem? How are we going to handle the eviction or the notice?
Well, and that's when you tell them, you know what, client, you better go talk to a lawyer about it. Because the truth of it is, it's going to, I hate to sound like, a politician or a lawyer, but it's going to depend on the facts and specific facts and circumstances.
Because I think the lease agreements we have, and probably Kevin knows clearly better than I do, but I think the lease agreements that we currently have on our homes mention something to the effect of, for sale, that we have to just cause, so when these things exist will, now we eliminated that.
Yeah, there are gonna be modifications to the car documents because of this.
Right, but the card document, so we have a lease right now.
Right.
So somebody used a card document leased from last year, and it does have that provision in it right now. So we're saying even though that provision is in there, still it's not.
Yeah, that's just what they wrote in a contract, but that isn't gonna change with the laws. The law says it sucks to be you. Oh, the law's after the document, and the law's gonna apply. I would love to have a contract that said, for example, I've had situations where somebody says, I'll waive the TDS, and it's the law, because we're tearing it down. And the answer is no, you can't waive the TDS, because the government said that's your protection. It's non-waivable. And you say, but they don't care, they're tearing it down. They're buying it from China. They're not even gonna see it. The dozer's waiting to tear it down. And the answer is no. The law says it has to be. The law is the law. It doesn't matter what people say or what they write in contracts. And we could get into a whole constitutional argument about the government impairing contracts and property rights, and then I'll go into sea change, and then it will be like an acid trip and you'll wish you never came. So, yeah, one more question, then I've got to keep moving. Yeah.
Could you clarify what this applies to? You said it doesn't apply to single family.
What if it's a fourplex building?
Then it applies. That's considered commercial. Okay. The question was, she wanted clarification on what this applies to, because I said it doesn't apply to single-family residences. It doesn't apply to condos. It doesn't apply to townhomes. And the answer is, she said, but what if I have a fourplex? The definition of a fourplex is that's automatically considered commercial, because even a duplex is considered commercial unless the owner is residing in one of those two units. Okay, now, the safe harbor of those being exempt, that's beautiful until it's owned by a corporation or a real estate investment trust, or some sort of formal entity may be the risk. So that goes back to my example earlier. Mom and dad have one unit and they put it in a corporation to protect themselves. Well, they don't have that protection for that single family unit anymore because they're a corporation owning it. Maybe you could do it in a trust. There may be some other ways, but you got to talk to a lawyer about that.
LLCs also, live in that?
So they don't specifically say LLCs, but it's registered with the Secretary of State, and in my opinion is, yeah, an LLC, a corporation, a formal entity, guess what? You're considered commercial.
So large
at that point.
apartment complexes.
Oh, all that.
Anything over 4 units.
Well, it could be 2 units if an owner's not occupying it. So basically, you've got to say to yourself, if it's more than a single family unit, unless it's 2 and I'm occupying it, bottom line is if it's more than 1 unit, then I've got to say to myself, and it's owned either more than 1 unit or owned by a corporation or some formal entity, I got a problem. Which is basically the mass volume of property that we're dealing with. We're not, this isn't all, Airbnb and little mom and pop units in the back that we're talking about. So anyway, you bet. Another reason, intent to demolish or substantially remodel. I went into the substantial remodel. And then the owner is complying with a local ordinance, court order, or other governmental entity resulting in the need to vacate the property. So if the property's red tagged, if it's going to be demolished, if there's a government taking because they're expanding the freeway or whatever it is, I guess you got a different problem, okay? But at least you've got an excuse with the tenant. And then another one could be a going out of business, some sort of bankruptcy issue. Maybe there's going to be some cute people playing some games there. Again, that's going to be a whole big lawyer issue, but you're going to be stuck with that. Is selling the property a just cause for eviction? No, it's not. Because people sell properties, but they're going to have to sell it with the lease in place, just like you would any commercial unit, and the new person's going to have to assume that lease, and there you go. Well, so, to me, that probably depresses resale. That's probably why the Army's going to get concerned, yes.
Still 60-day notice, about a year?
Well, so we'll get to the notice in a minute, but the notice isn't just a 60-day, you've got to give reasons now. And if they're violating something, you've got to tell them before you give them the 60-day notice, hey, here's what you're violating, and you have to give them an opportunity to cure. It's like mom and dad have to tell you that you're going to get a timeout before you get the timeout. And then after you still say nah, 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 then you can have the timeout. So you have to warn them. We have to protect these people. So, this is just, they're a special class of people, and that's the way the legislature wants to make sure they're not being abused. Okay? Now, what happens though if I have a legitimate reason? I have a no-fault reason to get rid of them. I'm doing the substantial remodeling. I'm demolishing the unit. I'm going to move in myself because I need a place to live. Now I'm downsizing and this is what I'm going to do. You don't just get to say, too bad, so sad, hit the bricks, you're out. It comes at a price. Nothing's free under the law. Okay, so the question is, what happens? Well, you have to give them a relocation assistance amount or a waiver of rent. We have to protect these people. Okay, so how do you do that? How much is that? It's a payment of 1 month of the renter's rent in effect as of the date of the notice of termination of tenancy was issued. So if you've raised the rent twice in that 12-month period and now you're going to give them the notice, it's not based on the cheapest rent that you had at the beginning because you want to be cute. It's the rent that's in place right now. Okay, 1 month of rent. Okay, or you can issue a credit for 1 month's rent. Okay, that's another way of doing it. And a written waiver of the payment of the last month's rent must be provided to the renter prior to the rent due date. So you got to give them enough notice to, basically comply with that. If you're going to pay them the amount of money, it must be paid to the renter within 15 days of the service of the notice of tenancy. Now, some people are going to get frustrated because they're going to say, well, I don't want to pay them until they're out. What if I pay them and they still don't leave? Sorry, law doesn't help you there. Got to pay them within 15 days, and they're going to be out in another 45 after that. Well, you'll have a reason to evict them now. Congratulations, but you've just given them money for a lawyer maybe or whatever. That's the law. That's one in their infinite wisdom, something they added in there to make sure we're protecting these folks. Yeah, that sucks, okay? And then people say, well, I want to be creative. Can I give part as a waiver and part as money, maybe a moped and some groceries? No. No, it's one or the other, folks. Pick one, pick the other, make it clear, and that's what you have to do. They don't want you giving combinations or special formulas, probably because they know that once realtors start doing that, it becomes a little scary. Okay, what happens if I fail to pay the relocation assistance or provide a rent waiver? Then the notice of termination of tenancy is void. Ooh! So I didn't offer them the money because I thought, maybe they haven't gone to Google and figured it out. Maybe they haven't talked to anybody. Good luck. Presume everybody goes to Google and they're sufficiently misinformed to make your life miserable. Just assume that. The notice of termination. So you terminate, you tell them you got to get out. These are all the reasons. This is no fault. And you're saying, I'm going to move into the unit or I'm going to substantially remodel it. But you just forget to tell them about the right to the relocation assistance or the waiver of rent, because you're hoping they just don't know. Can't be cute like that, because if they figure that out and they talk to somebody, the notice of termination is void. It doesn't take effect. So they're going to not leave. Or if they've left and they find out later on, they're going to sue you for breach of the lease. And they're going to get a lawyer, and the lawyer's going to say, you have to pay to relocate me. I have all kinds of damages, probably an attorney's fees provision in the lease. Your landlord's going to be real unhappy if you're a property manager and you got them sued that way. So their landlord's going to be coming back to you for all those damages. So you have to make sure you comply. You don't want to take any shortcuts with this one because it's going to be hell to pay.
Robert, can I interrupt
Yeah.
just for a second? Okay, everybody, it is after 11 o'clock, so we are good to be here until 6.
Bob, what about leases that are expired and have gone month to month for
As
relo?
long as Robert is willing to be here and answer questions, so we'll stick around for a little bit. Okay, and then we'll do a closing when that's done. But we've got room till 12:30, so we're good. But again, it's up to you.
I'm good.
You're doing great. Are you buying lunch?
Yes.
Leases that have expired and have gone month to month.
So the question is, what happens if I have a lease that's expired, it's gone month to month? You still have an obligation
To consider to renew, it's a lease. So they don't get into this, you're special, you're month to month. Now, there are some exemptions for temporary lodging, hotels, dormitories, things of that nature that we can get into if we get that far. That's probably why I should take no more questions and kind of keep blowing through this. But anyway, yeah.
I had the same question he had, but I don't feel there was an answer.
So when you go have a 1-year lease, and then in the lease it goes month to month after that, and you want to in the lease, you still have to give them relocation assistance if you don't want to renew the lease with a tenant.
If you don't want to renew with, you have to give them an option to renew. And if you don't give them an option to renew, then the only way, and they don't want to leave, then the only way that you can get rid of them is basically through a no-fault, an at-fault provision. You've got to commit a crime at the property. Maybe you'll pray for that, I guess. Or you've got to do a no-fault, and then you've got to give them the relocation assistance or waiver.
So all leases have to give them the option to renew? Can you write a lease that doesn't have an option to renew?
Yeah. Yeah, that's where they've totally changed the dynamic. I used to say to myself, I'm going to take a tenant, and I'm going to take a gamble on you. It's a little bit like dating. I'm going to take a gamble. You know, I don't know. I'll go for the second date. Maybe I won't have a headache when I'm done. I don't know. So you take a gamble. But sometimes by the end of the second date, you're like, oh my gosh, never again. There's no third date. You don't get to do that with the tenant. When you enter into a landlord-tenant relationship with the tenant now, you have to give this individual the option to renew, even though you don't want to renew. So it's kind of forced dating, so to speak. You know what? We'll take the questions afterwards, because otherwise we're going to get about 16 more, and that won't work. Okay? And I know it's frustrating. I get it. Didn't write it. Don't like it. Okay? Okay. Vacancy decontrol I talked about a little bit before, but the beauty of it is when you finally get them out, they decided they wanted to move, send them a fruit basket, you know, thank them for leaving. What a weird relationship. And now you can raise it back to market. So what I'm going to do if I'm a landlord is, perhaps when I don't want to have my tenant in there anymore, I'm going to be as close to a slumlord as I can get away with so that you don't want to stay in the unit. I'm not going to want to enhance the property because I don't want you to like it. I want you to leave, which is not really a good business model. I want to rent, but I don't want to rent. Kind of bipolar, and there's no medication for that. So, other than voting, okay, and your donations, okay? So, provision to the tenant regarding the rent limit. Now, there are noticing requirements under this law. You have to make sure that you're providing the proper notice. And I believe that part's in the handouts where we've actually quoted it. And it basically says a landlord is subject to the new law must provide the tenant with the following notice and no less than 12-point type. Let's not get cute and cram it into the page and go 11 because some paralegal will catch you out there and say that you didn't give proper notice. Okay. Timing of the notice. So again, with the timing, when do you need to give this notice? And they basically say it's the July 1 of 2020, even though the law is taking effect, they're trying to stagger it in. But truth be told, I would be putting it in my leases right away. Why would I wait? I'm a big believer in if there's no downside to giving the notice now, why wouldn't I just put it in now and be ahead of the curve so I don't have to deal with it? You know, I'm a big believer in do today what you can. Don't wait until tomorrow, because in my world, you know, with litigation, it's like an air traffic controller. If I wait till all the planes are circling the airport, and there's too many of them, some of them are going to fall out of the sky. So if I can land some early, I'm going to land them early, okay? New leases, okay, after July 1st, 2020, we went into that. Okay, and relocation assistance, we talked about that. Property exemptions. Now, if you have a property that's exempt from the law, for example, the landlord must nonetheless provide the tenant, this is up front in your lease, okay? When you're doing the lease to the tenant, if you believe you're exempt because it's my single family residence and I own it in my name and it's not in a corporation and I'm not a business, I'm just, you know, a mom and pop, here I am, and I'm just trying to rent it out, even then, I have to give the tenant notice in the lease talking about how some properties could be subject to this rent control. I have to inform the consumer why mine doesn't apply. They just really want to make you a soldier of information to make sure the world knows that they have these rights. Maybe they want to go rent somewhere else before they sign it because now they realize there's this risk. So you have to put this notice in. And again, if you don't give people notice, then you can get into a host of, you know, if you later on you give me notice it's not valid, or maybe the lease in and of itself is invalid, and you're going to get into a lot of creativity with lawyers making your life miserable. So we want to make sure we comply, and we quoted that law.
For you, What if the tenant refuses to acknowledge that?
Well, it's like any time a tenant refuses to acknowledge something. I don't know how a tenant's going to refuse to acknowledge a notice that you put in their lease if they don't sign the lease.
Well, what if they're already in the lease and like in December when the form comes out and send it to them, what if they refuse to acknowledge?
Well, when you give them an option to renew a lease, it's like anything. It's just like a notice. You're going to need to have what the court deems adequate notice. Okay, now I trick people. I mean, I send them an email with it and I give them a reason to reply to me. Okay, I usually, I don't, because I know it's got to be a two-way exchange with human beings sometimes. So I usually give them a reason to want to reply, and then I get the reply back, and I go, gotcha. And then I just save that little one over to the corner, and I make sure I have it. But there are lots of ways to do it. You can be creative in a good way. You could, for example, while you're doing the smoke detector check, you could bring it to them and say, I need you to take a look at this, and I need you to sign it. Or you could leave, they'll say, well, I won't sign this. My husband has to read it. He's a JAG officer. He knows everything. I'm not signing this. I don't really know. And you say, okay, that's fine. Then what you do is you'd follow up with an email. It's a pleasure seeing you today at the properties. I left the attached. You'll send a confirming communication that you're going to save. And they're not going to have proof that they disputed that. And if your understanding differs, please let me know, that sort of thing. You need proof is the bottom line. Because that is, people do play games like that. What are the just cause evictions, exemptions, transient and tourist hotel occupancy? Because obviously, if somebody keeps staying, night after night at a hotel, we don't want to be subject. Yes?
Back to that last point you were on, I just have two questions.
Yeah.
If you have month-to-month rentals, do you have to rewrite your month-to-month including this because of this law? And the second question is, how many properties are exempt under this, or is there a limit if you have 10, 15 under mom and pop situation?
Okay, so the first thing is, if I'm going to continue a lease, that was a month-to-month, do I now need to give them the notice? And the answer is yes. I think you do. So you're going to have to, because the law says you've got to give them this notice. So now what you could do is you could give them the notice and they could refuse to execute it. Because some people will do that. They'll be like, I don't know what this is. You're trying to get me and I'm not going to sign it. And you can say, thank you for not renewing. That's awesome. So that would be one if they don't renew it. And the question is there a limit on what if I'm mom and pop, but I own 10 single family residences in my name, not in a corporation or LLC? I didn't see in the law that this specifically addressed that. Although I've got to tell you that if I own 10 properties, and I'm a landlord, and I don't have that in some sort of corporation or some sort of entity protecting me, I don't know that that's the risk that I would want to be going to bed with every night. I think that's a real issue. Yeah.
What if you've had a relationship with the tenant via DocuSign, and you've had them DocuSign documents before, they signed them back, can you shoot out this in a DocuSign form, and maybe a couple of reminders on the DocuSign? Is that adequate?
So the question was, what if I have a DocuSign relationship with my client? We've engaged in DocuSign. We've been DocuSigning, and that's the way we do it. And so you're into that. That's fine. Tenant seems to be good with it. It's a consensual DocuSign, whatever. And it's politically correct, all that. Can I send a DocuSign as proof? Will that suffice? And sorry to be a lawyer. I would say yes, but. The but is, when they say I changed my email. I never got it. I stopped using my Sunderland at Gmail, and I decided that Hotmail, even though it was antiquated, now had an attraction to me, and I'm a Hotmailer, or whatever it is. So now the DocuSign relationship, if it wasn't a Hotmail relationship as well, might be an issue. So the answer is, it depends, because you've got to prove that they were still using that email and they received. The burden's going to be on you to prove it. That's the risk. I think that's a challenge we have, yeah.
So just take it one step further, what about a text message? Send that version of text message and they reply.
Okay, let me talk a moment about text messages. Thank you for asking that, because this gives me an opportunity to go on a rant. They have often told me that if I talk about these things, it will make me feel better. And so I thank you from the bottom of my heart for asking about text messages. What if we send it by text message? Texters of the world, I understand that we live in a text world. In my world, texting is for, I'm at the curb in the gray car, honking the horn. Where are you? That is what I use texting for. I tend not to use texting for business. Now, why is that? Well, because are you saving all your text messages? Some of you are. Some of you have the app to do it, although those apps aren't always as good as you think they are, and they don't always work as well as they should work. But if you're not saving your text messages and you're conducting business as a real estate licensee, and it's germane to your transactions, and you don't have them, you're non-compliant with the DRE. Because the DRE says that if you're doing a licensed activity and you're communicating, you have to have the communication. So, as we all know, anybody that's ever engaged in an argument with a significant other, they always take the phrase, but you said. There's those 3 choice words, you said, that they use against you. Well, when somebody files a complaint against you, they take the portion of the text message that you said this, and you're like, but afterwards I said this. They don't give that part to the DRE when they file the complaint. They give the part that helps them. And you're like, but what about the emoticon? What about the happy face? And they only show them the WTF. You know, they don't show them the rest. So texting is an issue because A, you have to have a complete chain, and if you don't, the DRE's immediately going to say, gotcha, you don't have your text messages. So then you say, but it's okay, Rob. I'm going to get my text messages from Verizon. I'm going to call up Verizon and I'm going to ask them for my text messages. And you know what Verizon's going to say? Sure, we'll give them to you when you get a subpoena. And you say, a subpoena, they're mine. I pay my bill. I've been with you since before you were Verizon. I want my messages. And they say, it's not just you. It could be Andrew Weiner on the other side of the text. He has privacy rights, maybe. And so we're not just going to barf those things up without a subpoena. So now here's what happens. I know I'm on a rant, I know, but thank you for letting me do this. What will happen is you'll do the subpoena, and everybody else in the lawsuit will find out about the subpoena, and there's no filter for what gets produced, ladies and gentlemen. All your text messages barf out. All of your text messages. Did you hear the all part? It's the business, it's the dinner reservations, it's the text that I didn't want my broker to see because I was talking smack about the broker. It's I got the illicit accidental text that wasn't meant for me. I don't know who that is on the other side of the text message. Why is Andrew Weiner texting me? I don't know. Bottom line is, all of that stuff gets produced. And I have to tell you, ladies and gentlemen, there's certain things I don't need to see when I'm defending you. I don't want to have that relationship with you, okay? And I will have to do some deep therapy when I retire because of the things that I've been forced to see. And I will be honest with you as well. Behind closed doors, I laugh at you. I laugh at the things we see. We joke about you. We do. You all have nicknames, all of you. And so the bottom line is those texts wind up getting produced. So I'm not a big fan of texts because it kind of opens up your whole world and your private world when you're using your phone for personal and business. And you have to save those texts. But to get back to the question, if I send them a text, is that okay? Well, if you have the text and you can prove it, in theory, yes, that might be okay. Although, of course, now you've opened up this whole other issue.
Well, tenants love to text. They don't want to write anything.
They do.
So they give you notice in a text.
Right.
Anything.
Well, you could tell them, I'm going to be at the property tomorrow. I'm going to give you this new lease. We're going to meet. You know, I've given you the 24 hours notice or whatever. And, you know, I'd like to pick it up then. Okay? And then you're going to have that. And you're going to document that in your file. I went to the property and I asked for it and they refused or whatever. It's a business record, a contemporaneous record. You write these things down. Notes matter.
Early on, you said commercial has its own set of exemptions. Could you speak about commercial and more importantly about mixed use, like where there's 2 or more residential units on a commercial property?
So the question was commercial, how does it relate? And what about mixed use commercial where there's residential and there's commercial? How does that apply? Because clearly, if it's a taco shop, you know, they're not going to be subject to the rent control. We care about the people that are living there. And the answer is, if you've got 2 units and it's commercial, but you know you're renting it out to an occupant who's leasing it to live there, it applies. As for the other commercial exemptions, that gets into the dormitories and interim usage like hotels and things of that nature. And obviously, it's not for somebody who's living there as a residence. But if they're living there as a residence, your assumption has to be residential occupant, they're sleeping there, they're living there, they're allowed to sleep there, they're allowed to live there. They're going to be subject to the law, basically. I mean, that's what you've got to think, okay? We got to blow through, we got just a little more time. So the evictions, exemptions, we talked about the dormitories owned and operated by an institution of higher education, but it also applies to kindergartens in grades 1 to 12, so boarding schools, okay? You're not going to have these protections for the rugrats, okay? Owner-occupied housing accommodations in which the tenant shares a bathroom or kitchen facilities with the owner who maintains principal residence within the residential real property. So that's I'm renting a room out in my property or something like that perhaps, but it's owner-occupied, I'm still there. New construction, we talked about the 15 years. Then we go into the rent control exemptions, which is pretty much similar. It's pretty much right on point. The bottom line is, you know, are there pros, are there cons to the law? I can think of a lot of cons. You know, I don't like it. I think it's too much control. I don't think it's going to be the solution. Again, I get to rant, but that's my opinion. I don't think the solution is to limit what people can do. And I think that what will happen is the savvy landlords are going to be cognizant of the law, and it's going to absolutely modify their behavior with tenants. To me, thank God I don't lease any more properties now, okay? But I know that if I were a landlord, and I try to be an exceptional landlord because I just don't need this stuff in my life, these problems. I deal with it all day long. That's why I'm like the best neighbor in the world, because trust me, I don't want to have a problem. I'm like a pushover. You know, I choose my battles. Those are the ones I get paid for, not the ones at home. But if I were a landlord right now, I would be treating my tenants a whole lot different than I used to. As good as I was, I would tell them, look, this is just, it's business. This is how it's got to be. This is what we're doing. This is what we're raising. And, you know, 7.2% in a year is a big raise. If we're averaging 7%, even 5% every year after year after year, it's probably more, some would say, than we should. It's more than inflation. But that's what the people tell you that like the law. You won't need to. You won't need to because you'll determine that that's too aggressive and the market will regulate itself. And so in the end, you'll eventually opt to only increase it 5% or 4%. Well, maybe eventually, but in the meantime, we've just made the problem a whole lot worse than it was because until we don't have a shortage, we know that there's going to be pressure to continue to drive the prices up and up and up. So it is not, to me, it's a guarantee of increases. And I personally think the consumer pays. I think they pay a penalty on it. All the way in the back of the mustache.
Just a quick question. I can see that the exemption is for single-family homes and condos. Is there a legal definition for a condo or a townhome that we can follow?
Yeah, I mean, if you look at, an attorney certainly can look at the title or the description and tell you. I mean, the definition typically is, you know, my first giveaway is it an HOA? Are there multiple units? Are there common areas? Well, that clearly is a condo or a townhouse, perhaps. But you've got to look at the legal description of the property. So the answer is yes.
I have a question that affects a lot of people. A lot of people have leases in place that are a year or so forth, and they revert to month on the CDR.
Yeah.
So when we want to execute, are you going to review for another year if it's been on a month-to-month because the language is similar terms? So
Right.
is it similar terms to month-to-month?
Well, I think it's the terms that are.
Or the
Sorry.
initial lease.
So the question is, it's a great question. So the question is, look, you know, we had an original lease that was maybe 12 months. And then it automatically, by the terms of the lease, went month to month. So that when they say renew the lease on similar terms, what does that mean? Does that mean the original lease with 12 months that goes month to month again? Or does it mean month to month? And the law doesn't specifically address it. That's a good legal opinion that somebody's got to give you. I mean, as a lawyer, I can give you both arguments, right? I can tell you, well, it's what's in place at the time. It's month to month. That's what it became. It was month to month. It didn't somehow magically not be month to month because it was month to month. It doesn't go backwards. It was a month to month lease. I think that's a reasonable interpretation of it, that it's a month to month. However, that does not mean that some ambulance chasing attorney out there isn't going to say, no, it's the entire lease. I want the 12 months, and the month to month. I don't believe the court ultimately would rule that way. I think they'd have to say it's a month to month. But just because I believe that, that's not the legal advice I'm going to give a client. I'm going to say, do you want to be the test case? And they would say, probably not. So you'd have to, and I'd have to delve a little deeper into it and probably take the 9th read for it to determine. But my gut tells me as I look at it that it should be month to month because that's what the lease is. It is a month to month lease. But I can make a very strong argument that, well, that derives from something bigger and we can't forget about that. So that the law doesn't say that. It doesn't talk about it. There's not a specific, and if it's this, it's this. There might be some clarification on it, obviously, as it comes out. But the other thing you have to watch out for is this is just the beginning. You know, you heard about National City and like 150 votes was all, I mean, you want to talk about voting makes a difference? Share that one with your kids. 150, that's like, you know, somebody just didn't put their foot on the gas pedal enough and missed to get there in time. I mean, that's a big deal. There's going to be more and more of this stuff. This is just a swell of what's happening. So, yes.
I have a couple questions, and I can say I didn't get it. If I put a property up for sale that has tenant month to month, and the property sells, the tenant does not have to move.
Correct. Just like it was always. The tenant's in place. You don't just get rid of the tenant.
So my next question is defining the if I have 10 properties, single family home, then my properties become commercial properties that are no longer a single person. I own them and I hold title as a single person,
right?
Not as a corporation, right? But they are commercial properties. Is that what you're saying?
No. The question was, if I have 10 single-family dwellings, am I subject to the law or not? And the answer is, if you hold them in a corporation, you're deemed commercial. If you hold them as an individual, the law doesn't say you are. Although I could see a crafty attorney saying, just like somebody who's doing a bunch of owner-builder permits, you get past a certain level, and I think you're a developer. I don't care what you say. It's a walk like a duck, quack like a duck, you're a duck. So I'm going to say that you're commercial and you're just evading it. But technically, if you have multiple properties and you own them as an individual, the law says that you could have a
So having said that, the Proposition 13, the state senator mentioned that I passed a provision that if you own multiple properties, you are becoming a commercial owner. Where it says, if you Google anywhere, it says you have to be an employer that has more than 50 employees to be subject to this legal Proposition 13. Okay. So which one is it?
One has nothing to do with the other. They're two separate laws. So it doesn't matter whether you have 50 employees or you have 2 employees. If you have a corporation and you have 2 employees, if you're a single owner, the law says if you're a single owner and you own a property, okay, in your name, you're not subject to it. Now, if you own 5 of them, I might make the argument if I'm an ambulance chaser that if you walk like a duck and you quack like a duck, you're commercial. And I believe the intent of the law, if I'm an ambulance chaser, is I think you're commercial. You know, you're not just mom and dad with 1 extra unit that you're going to move back to eventually or have your kids live in. You have multiple units. And I think you're commercial. So I think you're evading the law and you're being crafty and creative. The bottom line is you're asking yourself, perhaps, to be sued. You're already asking yourself to be sued because anybody who owns multiple properties in their individual name is probably playing with a little bit of fire anyway. Not a good idea. So either way, you got to go talk to a lawyer and say, what do I need to do to protect my assets? Because I'm concerned about that.
If an owner owns the property, it's actually a large part of the I guess that's the second property is 2 If the owner owns that in the name of his personal trust, is that's still not a corporation?
So the question is a trust a corporation? And the answer is it doesn't say it is. And so my belief is you can get around it with a trust. And that's probably what I would be doing with my properties, is I would at least have a trust, because that's better than just, hey, Rob Sunderland, come sue me. At least I got a trust out there giving me some protection for it.
Considered a corporation?
Nope.
LLC.
No, a trust in and of itself, because, you know, we all have, well, not we all, a lot of people hold their properties in a trust. It's It's becoming more and more typical. We see it all the time. That's why we have the trust advisory and why we have the RCSA and all those forms, because it's a pretty typical thing. So a trust in and of itself is a way that you can give yourself some protection. And that's not automatically corporation. You're not evil because you're a trust.
And the last part of that is a granny flat considered, would that be a
Now, the granny flat's kind of this ADU. It's its own special little sort of thing, but it also is going to depend perhaps on how you're treating it, right? The granny flat's supposed to be a granny flat, right? It's supposed to be for you to live in.
It's attached, it's an attached granny flat, 2 bedroom.
Well, if it's attached, it's not a granny flat.
Right, okay.
So it's detached. That's what starts making it a granny flat. So mom and dad, you don't have to hear them snoring. That's the idea. It's got to get
Attached would be
Well, attached is just part of the house. Okay, so that's just a house with another bedroom, unless you have a complete separate wall and, you know, no other way to get in there. But then you get into all the code weirdness, and is that even legitimate or not? The question is, what's it being used for? I mean, you're allowed to have a granny flat. You can put mom and dad in there all day long. But you start renting those things out, even if it was a duplex. If I'm living in the, even if they said it was a duplex, you're still living in the main house or the other house. You're living in one of the two. So you're okay. So you're okay.
Yes.
What about a condo?
Condo hotel. Well, that's a good question.
The hotel manages it
Yeah.
pretty much for us.
Yeah.
And there's
Well,
no-
a management company is just a management company. I guess the question is how it's titled is what it's going to come down to. How are you owning it? If it's Rob Sunderland, my condo, only my condo, just because I use a commercial property manager doesn't make it commercial. It's no different than using a property manager for any property that I own. Yeah.
Is individual owners, like we own our room,
Yeah.
the hotel manages it, so our.
Well, that's a common, you'll have common areas as well, but if it's fee simple and I own it in my name, then it's mine. It's a condo. And it doesn't matter who manages it for me. I mean, I think that's, I mean, don't invest that way based on what you heard from me today, because here, I got to give you the disclaimer for those of you who are still here. I'm not giving you legal advice that you can sue me over, because I haven't determined your individual facts and circumstances, because every transaction and event is as individual as the unique individuals in this room. So I have to hear those specific events to give you that ultimate opinion, but the bottom line is, in my opinion, fee simple in my name is a condo, it's mine. Yes?
If you sell property subject to a long-term rent,
Yeah.
and the new owner then immediately gives the tenants notice that they're going to demolish.
I mean, in theory, you know, an owner can do what you could do. They're the owner. So if they want to remodel it, they can remodel. They can do the substantial remodel. But what you've got to make sure is, so you don't have a problem with your new owner, you have to make sure that your lease that they assumed was compliant with the law, right? That you've given the proper notices and things of that nature. Because if not, I can see where the new owner's going to get sued, because, you know, the tenant's going to say, you know, I don't want to leave. And then they're going to say, you know, I assumed your lease and your lease was not in compliance, and I think that you didn't disclose that to me when I bought the property, and I think I've got a problem with you. But the answer is, in theory, any owner who's the legitimate rightful owner can do an you know, for a just cause, no fault, if it's applicable. But you still want to be careful. Yes?
I have a question about bringing your rent back up to market.
Yes.
So that can happen if the tenant moves out.
Yeah, the tenant leaves.
Okay, now how many times a year does that happen?
Every time a tenant moves out, every time it becomes vacant, you get vacancy decontrol. It's whatever you want to do. So if
Restrictions on that?
yeah, so for example, that's the one thing. You want them to die, basically. They got to go out in a box. Yeah. But yeah, if they leave like 6 tenants in a year, I don't know what the hell's going on at your place, but whatever, that's okay. Then you can raise it every time. At some point, there's only so much you're going to be able to raise it anyway, though. Yes.
Okay, so piggybacking off of Suzanne's question. Okay, you sell the property, it has gone it's gone month to month.
Right.
And the new owner says, okay, 60 days, I'm going to remodel this whole thing to Google, so I need you out. Now, does that fall under the year's current month's rent to compensate you for your relocation.
Yeah, so the question is, if I'm hearing you correctly, let me repeat it and let me know if I strayed at all. I have, and I'll embellish a little bit, I have what I perceive to be a just cause, no fault eviction. They call it an eviction, even though that's so brutally ugly, that word. You're not really evicting them, but that's how they think about it. But I basically buy the property and I say, hey, I'm going to remodel this property. And I want to give you notice that I'm going to remodel the property. Substantial remodeling, it requires a permit. You know, you'd have to be out of it for more than 30 days because there's no gas, electricity, I'm removing asbestos, whatever it is. Do I need to give the relocation? And the answer is yes. Yes.
Unless you are exempt.
And well, of course, if you're exempt, that's like saying, why am I talking about cancer if I don't have cancer? Yeah, then we don't have to do that. Yeah, if you're exempt, you're exempt. It doesn't apply.
If you have a property where it had an older house and you built a duplex on the back, which is within 15 years, how does that work? You've got the older house, which obviously you was subjected to it, but it was a single family at one time. Now you've got this duplex in the back, which has an under 15 years certificate of occupancy.
So the answer is I have a bipolar age issue. My property's old, like me, and my kids are younger, like my kids. Which is it? Is it, you know, I got a 15-year issue, which one does it apply to? And I could, you know, again, the law doesn't get that detailed. I guess the question in part would come down to, well, which one am I leasing out?
You're leasing all three, so
All three, I thought we had two.
let's say we have a single family in the front and a single family in the back.
A duplex,
The single family in the back is under 15 years with a new certificate of occupancy.
Okay.
The old house.
So the question is, we have an old 1960 house in the front, and we have a 10-year-old, casita in the back, and, what does the law apply to? Well, I mean, I think if we've got the brand new one in the back and that's what we're renting out, and you can, well, if you're renting both of them out and you're not occupying it, then I think the argument is the new one it doesn't apply to. But, you're already going to be on a slippery slope, because you know what most people are going to do? They're going to go to Zillow, Google, whatever, and they're going to say it's a 1966 property, and they're automatically going to think that you're doing something evil with a 1966 property, and then you're going to have the burden of proof to saying it doesn't apply on the back because the back's newer, that's a certificate of occupancy. Now, the law does very specifically say certificate of occupancy. So if I have a C of O that shows that the back is 10 years old, well, then that's not going to be an issue. Where I probably don't want to be too far in the weeds on this is, but now I've got two units, and one of them is and one of them isn't, and now is it exempt because it's only one family unit that's subject to the law that I'm leasing out because I've got two. And the law doesn't talk about that, and you are leasing two out, so I'd be a little careful on that, and I would absolutely want to have a legal opinion in writing from somebody who's insured, so that if it becomes a problem for me, then within 12 months of knowing, maybe I've got something that I can file or I can pursue, but you're going to want to look more deeply into it. Yes?
With these new rules on relocation systems, and it doesn't preclude you from working out a separate side deal with the tenant directly if you're trying to get rid of them in order to just pay and move out quick.
Correct. The question is, can we modify it? These are a protected class. You can't force things on them, but it also doesn't strip them of their free will. It's a little bit like a cash for keys, maybe, sort of scenario. Like, can't we work a deal out with them? However, you want to be careful because you don't want to find yourself in a situation where they say you bullied them into it and they had no choice and you didn't tell them. That's where, lawyers get stupid and do silly things. But the answer is, can you work a deal out? Bless you. And the answer is yes, I think you can work a deal out. It's a contract. But I'd be very careful about that. I wouldn't just want my property manager casually doing that because, sometimes they might say something wrong or whatever. You never know. Yes?
We've got two owners. One of the owners has it under a corporation, the other has a corporation. You take it out of the corporation.
So the question is, we have a property owned by two owners. One's me, and the other one's Sally's corporation. For whatever reason, I decided to do that, whatever. I'll embellish a little bit. First, do I have a problem? And the answer is, well, yeah, a corporation owns part of it, so that's a problem. So then the next question that you had, though, was really your question was, can I take it out of the corporation and get out of that? And the answer is, yeah, it depends who owns it. But you can't take it out of the corporation and then just go put it right back into the corporation. You know, you can't evade the law that way. The question is going to be who owns it. And so the real other question to follow up on that is, what happens if I owned it as an individual and I went to a lawyer to plan and decided, oh my gosh, I've got 10 properties held as an individual. I'm crazy. I absolutely shouldn't do that. And then I put it into a corporation after the lease. Well, the problem is now it's in a corporation. That's who's the owner. That's really who should be on the lease as well. That's the owner of right. And I think then you may put yourself into the law where you weren't in the law before. So you just have to be careful. But specifically to your question, if it's out of a corporation and it's in an individual's name, super. But, you know, why are we doing it? You know, are we being creative? Yes.
To ask the same question, if the two people own it are your relatives, or just two people own the property, would that be exempt still? As like the
So let's say tenants in common, let's say I own it with somebody else. You know, am I a business? I don't think you're a business automatically, but again, I guess the question would be, do I own a lot of properties that way? Are they an investment? Do I have a contract talking about I'm flipping these things? You know, you're going to have to drill a little deeper into it, but it's not a corporation. It's not an LLC. It's not what they don't like a real estate investment trust or whatever. But, you know, I could see somebody creatively saying, but you are in fact because of the way that you're behaving because of all these properties or whatever. But in answer to your question, no, if it's owned by individuals and not a corporation, technically you're compliant. Technically, but that doesn't mean somebody isn't going to challenge it because it's America and everybody gets to sue. It's what makes us great and horrible at the same time.
One other question. So what happens if you raise the rent and the person doesn't want to leave? The tenant, doesn't want to raise the rent or doesn't leave. Do I still have to pay them to leave?
No, if you're raising the rent and they say, I don't want to pay the rent, they don't have a choice. That's the rent as long as you're compliant. It can't be, it's not convenient, I'd rather go to Nordstrom. I mean, that's the rent. As long as you're compliant, they have to pay the rent. If they don't pay the rent, you may have a just cause eviction. Super. So let's hit them for 7.2% and hope they don't want to pay, I guess, so we can finally get that eviction on, whether it's a eviction or just a kind of eviction, right? I should go in the back right there, yes?
I read the bill and it talked about like calculating the maximum rent increase by like the gross rent, but it didn't define. Can you include like utility bill back or pet rent and then increase it on that?
Rent's rent. So I guess the question is, what is rent? Now that's sort of a what is, not to go Clinton on you, but you know, you know, rent's rent. So I mean, if you're getting away with pet rent, I'd be careful with pet rents, by the way, because who are we charging a pet rent to, and you know, are they protected and all that? But rent's rent. And if it talks about gross rent, if I'm charging rent for this and I'm charging rent for that, it would be the rent that I'm charging for the unit. So I think it would be the full rent. Now the utility, that's kind of a cost that you're passing on, and that fluctuates. If you would say, I'm including the utilities for $50 a month, and you know, maybe you can get away with it, but if you're just passing the bill through and it's up and down, and the summer it's high and it's low, well, is that really rent or is that really a utility, a cost that you're passing on? I would be careful there. Because the law, you're right, the law doesn't specifically say, well, a utility, that's okay. It doesn't tell you that. There's not a definition on it.
If we have owners of large apartment buildings.
Who aren't metered, except metered.
Right, and they're using like a comm service or whatever to like do third-party billing. Do you recommend they get an opinion of an attorney?
Absolutely. You should. Everybody in this room, sorry, you know, that's the one thing the legislature can guarantee is, you know, the legislature is often made of attorneys and they make sure attorneys have work, whether they know it or not. Yes, everybody should go to an attorney. And the reason why everybody should go to an attorney is because you don't want them relying on you for your legal opinion. The minute that CAR or SDAR does not have a form for you that basically has the breadcrumbs to the conclusion that you can walk through, they need to talk to somebody else because they're venturing into legal opinions, and it is unfair for that individual to hold you to that standard. You're not paid enough to do that. I mean, and it's not because we're great, it's because you don't want that liability. You want that to be somebody else's problem. It's no different than when you go to the doctor for your annual physical. Even a doctor will say, Mr. Sunderland, you've got a funny spot on your skin there. Now that could just be an ingrown hair, or it could be skin cancer. I don't really know what that is. Now, does the general practitioner evaluate me? Even the guy that went to med school, or gal, they say, you need to go to a specialist. Part of that is they want to charge you, I think, and they want to make sure they're within the insurance guidelines. But the other part is they don't want to get sued because they're not a dermatologist. So they send them to the specialist. So anytime you get beyond what you are learning as your continuing education, okay, then they need to go talk to somebody else. And that's why I have my little speech, which is sometimes you don't, you pay me to tell you what you want to hear. That's part of it. You want to hear, we sold your property, we leased your property. That's part of what you pay me for. You pay me to give you advice at appropriate times. You also pay me to tell you what you don't want to hear. I go to the doctor for my annual physical. I hate going to the doctor. Who wants to go to the doctor? I got better things to do. But I go. Now, I hope the doctor is going to tell me wonderful things. You look good. You're doing all right. Your cholesterol is good. Your weight's good. You even have a head of hair. Congratulations, whatever. And I'm happy. But that's not why I go. I hope they're going to tell me all the wonderful things. But in the end, if they see anything that's bad, I might not like hearing it, but I'll say thank you. And then I'll do what I need to do. So I go to hear what I need to hear. And that's exactly what our clients come to us for. And so we have to know when to push back and to say you need to talk to somebody else. So my position on this law with a landlord would be, unfortunately, whether you're red or you're blue or you're in between or whatever, this isn't a political statement. This is the law has changed dramatically in a very short period of time. And there are significant consequences to this. So when you're asking me what you should do, I'm telling you should talk to a lawyer about it, just as if you came to me and you said, but I have treated it with my taxes in the past where I depreciated it and I want to do a 1031 and I'm doing a change and there's a trust and maybe there's a corporation and a cousin and a whatever and an investor. You're like, whoa, I don't know, man. You got to talk to a CPA. And so you give them that type of example and you kindly have them talk to an attorney, and they won't. Sometimes they'll say, I don't care, just like the person's gotten one physical inspection, they're not going to follow up and pay for more. Then you give them the email, as we discussed, this was the concern, my advice does not extend to that sort of thing. I can't give you the opinion on that. You have to tell them. You have to protect yourself. One quick question.
So I just recently learned that this would apply to like the price gouging law that goes into effect during a state of emergency, or so like right now, if a tenant vacated, you could not bring it to market, right? Because you could not raise it more than 10% of what the last lease was, right? Because of the fires and the governor calling it a...
Yeah, I was up in the Bay Area at another one of these meetings.
Right.
With car legal there.
Right.
And they said that all of the state of California currently is in a state of emergency, so that the 10% max applies to everybody, whether you're exempt or not.
That's an interpretation that I've heard by multiple parties. So that is what I've heard. Is there a test case? Has it gone to the appellate court? And the answer is no. It's early to tell. But what I would do is, I would want to raise it certainly 10%, right? And if you want to go beyond that, well, you need to know there's a risk. Somebody may come back on that and say, well, there's a state of emergency. Do I think it's a state of emergency? I haven't seen a tsunami, I mean, I haven't seen civil unrest. Where's the National Guard? They're not outside my apartment building. I don't get it. But, the government does what the government does, sometimes for better or for worse, all the way in the back. Yes, that's you, yeah.
Isn't there any deadline for send out the notice of exemptions for existing tenants if they are on monthly or they are on yearly fees?
So the question is, are you asking about the notice requirement? Is there anything online that I can obtain?
So there's notice of required to send out to the exemption,
Yes.
The exemption entity or something?
Yeah.
So is there a deadline? When do you need to send it out if that's for existing tenants?
Well, I think it was July 1st of 2020, although it's in the handout. You can cut and paste it from there, or you can pull it right out of the legislation. I wouldn't wait until July 1st of 2020. I would probably just start giving it to people to be done with it and check the box off. You know, in my property management folder, I'd have a checklist, and that would be one of the things that I checked off to make sure that I'm compliant. I would add that to my list starting now to protect myself. Yes?
I had a question about the reach back date of March 15th.
Yes.
If on the inflation percentage, if it was the 2.2% that you mentioned, so 7.2% total, if I didn't have any of these renewals in March, but most of them were in May and June, and that CPI inflation rate was 3.8, do we go off the 8.8% if we renewed in those months, or do we have to go back?
Well, it's over a 12-month period, the CPI, okay? So you can, you know, if you want to raise it, that might be a reason why somebody would raise it twice, because they want to do an adjustment. That may be another reason why some landlords all of a sudden like having leases that come up in March, you know, which is weird, because that's not the way the world works. But it's over a 12-month period. So although the law's in effect on January 1 of 2020, what they're going to do is on that day, they're going to say this lease started back then, you're going to have a cap within a 12-month period. So if you've already gone above the, you know, whatever the percentage is in that interim period, okay, then you're in trouble. You've got to reduce it right away, and if you do it on January 1st, then you're not going to have a problem. And then, of course, if you go to that later point where it becomes 12 months, you might want to true it up, right? There may be something that you can do to adjust it up or whatever, but you got to make sure that you're still in compliance. You still got the cap over a 12-month period, okay? Yes?
I just want to make sure I'm understanding it correctly. I think for existing transactions, say right now, that might cross over into the new year.
Right.
Say I have a buyer of a property and there's tenants in that property.
Right.
Now, should they be sending them a notice of exemption even though it doesn't apply till the first of the year? I don't want to have something come up.
Well, all right, so great question. I have a pending transaction. I don't want to weird people out, you know, and rock the boat. So Rob, you're very cautious and you want to get things done early because it's smart. Again, I'm adding more words. But do I really need to give the notice for something that doesn't apply yet, when technically I wouldn't even have to give it to July of next year? And I'm very reluctant to ever tell realtors not to do something, because they take license with that and then they think it applies to everything. But in your very specific, unique fact pattern, if I have a pending deal that's going to close and legally I'm not required to give the notice yet, should I give the notice? I guess you're not required to. So that's a judgment call. The only question that I would have is, it goes back to a question that I had from the front row earlier on, which is somebody assumes the lease and later on there's a problem. You know, I think you could say you were compliant at the time of the sale because it's sold. I think it would be different if the transaction closed after the first of the year, perhaps. So I think that's kind of the pivotal date for us, is, you know, when the pumpkin drops or the apple in Manhattan, you know, and Ryan Seacrest or whoever's doing it, you know, says their little thing, that's going to be the time that you need to lose sleep. Yeah. Well, and even that, theoretically. Yeah, I would do it if I knew I was selling it later in 2020. Theoretically, July 1st is that operative date. So it's always going to be based on, you know, if you've got a really weird situation, you'll have to decide. Personally, I would just do it certainly in you know, January 1, and I'd play it safe. All the way in the back, holding your hand up. Yes?
What, as a previous homeowner, what wording would you put in a new lease now?
What wording would I put in a new lease now? And the answer is, what I would do, my own lease, but of course, you know, it's sort of like you're going to the guy that's going to be hyper technical about it, is I'd put everything in the lease right now and be done with it. I'm not selling my property. I'm just going to be over it. I'm going to be done with it. I'm modifying my leases now. I know I'm compliant. So I would do it all now. That's me, because I'm a lawyer. I'll go home, I'll do it. I'm weird. You know, I stay up at night, I read this stuff. This is what I do. You know, what are you going to do? Well, you're not going to go to Google and do it. You might say, I don't want to pay an attorney just yet, because that's kind of overkill, and I appreciate that, I do. What would you do? I would wonder how quickly CAR's going to come out with their form, and I'd harass Kevin, because I know he said they're meeting on December 4th, and I'd say, how quickly do you think you guys are going to get it out? Because we need it. I need it as soon as possible. I'd like to have it. I'm a big believer in any time you can use a CAR form, or you can use an SDAR form, that's a great way to go. Because it's the benefit of the collective wisdom of a vast pool of resources that they have at their hands. It's not just one lawyer. Because even an exceptional lawyer is just one lawyer. And realistically, when you have a room of lawyers that are exceptional lawyers working to the same goal, you can do a better job. So I'm a big believer in the forms. I've always been a big believer in, if there isn't a form for what I'm trying to do, I need to go talk to my broker, or I know I've got an issue because I shouldn't be writing it. Which goes to my last point, which is when you're writing your disclosures or you're doing things, if you get to the point that you're putting a comma in the sentence, you're getting a little long, careful, got to dumb it down. 12-year-olds have to understand it because that's the jury pool. I mean, it's kind of the people that don't get out of jury. Keep it simple. I always said if I could explain it to my kids when they were in 6th grade, I had something. I was pay dirt. I was good. And I'd explain cases to them. I'd say, does that make sense to you? And they liked it. If you get to the point, if you remember before we all text like mad, that you have a semicolon, you definitely, that's a period. It's not a semicolon. It's a new sentence. Short. I'd rather have 3 boom, boom, boom sentences that I know what each one means versus the, where's the special decoder ring from the Cracker Jack box to figure out what you're saying because it's, taking me like this. McCutchan writes that way. I didn't say that. Anyway. Yes? Well, it's basically going to be over the last 12 months, but it only reaches back to March. So I'm going to look at March, right? Yeah, and I might want to do a true-up in February. If I think I'm a little bit off or whatever, I might look at it. So that's the other question. When do they want to do it? Do they want to do it twice? Do they want to wait until they've got better data? That's their call. Okay? Somebody over, yes? Right.
And they're going to rent out the rent as well. This law now affects.
So the question is, single-family residence with a granny flat. Owner doesn't occupy either unit. Owner wants to rent it out. Is that a duplex that an owner's not occupying and therefore subject to the law? I would want to have an opinion from a lawyer on that. Yeah. Now, my opinion is somebody's going to say that, yeah, that's commercial. Because we kind of go to the intent of the ADU or the granny flat, and really why do we have these? It wasn't to create a bunch of, that wasn't to deal with the rental crisis, that was to deal with a housing crisis for family that need a place to live. And so that was the intent. And so my argument as a lawyer challenge is going to be, they're getting around, that's not the intent. You're not living there. This is commercial. Walks like a duck, quacks like a duck. Come on, you're renting them both out. Give me a break. This is what the law is written for, exactly this.
In closing?
In closing? One more question. You pick the person.
Right. You gotta go. I mean,
We gotta go.
Okay, so here's the deal. Here's what's gonna happen. This was taped today, so it will be also available online. We'll have that available for you. Okay, Drew in the back will give you a high five. We're gonna do that. What do y'all think? Should we do another one?
Yeah.
Okay. So, but listen, I have to thank Mr. Sunderland. I think he's an excellent attorney. I love working with him. We booked him at 1 hour at $1,500. He's been here for 2 hours. No. He's been very gracious. He spent all this time here. He spent twice as much time as he had told us that he would, and we really are so appreciative. The information is always good. It's definitely a hot topic. We have more coming. So again, another round of applause. So a couple things just really quick before you go. So we do have a form coming out. All right, Mr. Sunderland referred to that form. The Standard Forms Advisory Committee is working on it right now. They have promised us that it'll be ready by December because we need to have it in all of your leases. People asking the question about, do I need to put it in the new lease? If you don't give notice to the tenant, then you may not be exempt. Okay, so you need to make sure that you use the form. Ryan in the back has a list of, or a handbook.
The handouts.
For you
Or
to
the
help.
good one.
On December the 4th, we will have a webinar. That will cover the new forms that are coming out, and that will be at 1 o'clock in the afternoon. And those will cover the new forms that are coming out. I think personally we're going to have a second one that evening because there's a lot of material to cover. So just be aware of that. Also, we don't believe at the state level that it's done. We think there's going to be some litigation that's going to be coming that's going to clarify a lot of the issues that we have in this room. You all asked really good questions. I got to tell you, I'm sitting over here going, yep, that's a good question, that's a good question. Fortunately, we had great authority here to help us with the answers. So our special thanks to Mr. Sunderland. And he also mentioned something about that email. Remember that email that you send out to people? Okay, so we call it a confirming email or confirming letter. It is available for you in the San Diego Association of Realtors Risk Management forms. You need to be using that, okay? You need to be confirming with your client the fact that you said something. He just said so many great things here today. I ran out of room on my computer for taking notes. So but our thanks especially to the Greater San Diego Association of Realtors for hosting this event. We are so pleased that you came. We originally scheduled for 100 people. We sold out in less than an hour. And then now we moved this up to 200 people, a 200-person room. And thank you to Ryan for actually locating it. We had to search everywhere to find a room that could take us on short notice. 200 people, and we went past that number significantly. So I agree. Everybody think we should have another one?
Yeah.
Maybe a little closer into December, when just before the law is enacted.
Yeah.
We're on it. Okay. Thank you all for coming.